So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on. All right?
Yes, sir.
All right, let's get started then. How old are you, sir? And I know how old I am.
I got seizures left and right, and they got me on the top bunk, so I fell off and hit my head on the toilet. But
so you don't know how old you are?
Me? I'm 33.
Well, that's the question I asked. How old you were?
I thought you was talking about how I was doing today.
He thought you said, Your Honor, if I may, how he was doing today.
I heard him. Approach for a second. Well, Mr. Marshall, are you not feeling well right now that we can't do this hearing right now?
I'm fine.
Well, you didn't sound like you were fine. I asked you how old you were, and you started telling me about you fell off the bunk and hit your head, and I don't know what impact that is having on you.
This is fine. I'm just a little...
You're a little what?
I don't know. I'm like... Just my head hurts just a little bit, but I'm fine.
Well, if your head's bothering you and you're not a clear judgment, I'm not going to do this hearing right now.
No, it's fine. I'm clear. I thought you said something else. I didn't know.
Well, what happened that you fell out of and you hurt yourself?
I'm having a seizure.
Okay.
And I fell off the top bunk.
And what happened?
I woke up laying on the floor.
When was this?
Like 3-4 days ago.
And what's been going on since then?
And I try to switch to the lower bunk, but it's a big argument between me and my roommate, but it's fine.
But I'm talking about when they say what's going on, what's been going on with your physical health in regards to that fall. I'm assuming when you fell, you hit your head? And what's been going on since then, what's in regards to your head injury?
I just got a little bump on the left side of my head.
But how have you been feeling in terms of, I mean, you've made a point of it here today. You're saying that, obviously you brought that up for a reason. Why'd you bring it up?
I thought you said something else. That's my apology.
Are you saying you thought I said something else because of the head injury you sustained that's causing you to be able to hear me clearly?
Yeah, but I'm fine.
Well, you're not fine. If I'm saying one thing and you're hearing something different, you're not fine. You brought that up for some purpose in terms of this head injury that you sustained.
I didn't hear you correctly. It's my apology.
Well, you don't have to apologize. I just want to make sure that you're of clear mind right now. I'm going to be asking you questions for about 20-25 minutes. And you're going to have to be able to understand what I'm saying, and you're going to have to be able to process what I'm saying and answer those questions appropriately. And the first question I asked was how old you were. Now maybe I didn't speak up loud enough or I was clear enough, but then all of a sudden you went right into this, you fell out of your top bunk and banged your head.
It's my apology. I thought you said something else.
What did you think I said?
I thought you said how I was feeling today, how I was doing.
Okay.
I didn't hear that part.
All right, well, let me ask you, how are you doing today?
I'm fine right now, because they got me on medicine.
What medicine are you taking?
They only got me on Motrin and Tylenol.
So some type of over-the-counter painkiller?
Yeah.
In the last 48 hours, what medications have you taken?
Just my seizure medicine, Keppra.
How often do you take that?
In the morning and at night at 10 o'clock.
Did you take it last night? Did you take it again this morning? What effect, if any, does that have on your ability to understand or appreciate where you are, what's going on around you?
When I slip into one, the next day I don't remember what happened. Somebody's got to tell me what happened.
When you slip into one? When you slip into a seizure?
Yeah.
When's the last time you had a seizure?
3-4 days ago. My roommate told me what happened.
So in the last day or two, you have not had a seizure?
Only that one.
That was 3 or 4 days ago? So right now as you sit here, is there anything impacting your ability to understand or appreciate where you are, what's going on?
No.
So you spoke with your lawyer before I came in here, and you don't need to tell me what you talked about, but did you have any difficulty communicating with her?
No.
You understood what she was telling you?
Yeah.
And you can communicate with her? So right now as you sit here, is there anything impacting your ability to understand me when I'm explaining to you and appreciate your surroundings, anything like that?
No.
Can't hear you.
I said no.
Aside from the prescribed medication, any other drugs or alcohol in the last 48 hours?
No.
So just the medication for your seizures and then some Motrin or Tylenol, something along those lines?
Yes.
Nothing else?
No.
And none of that's affecting your ability to appreciate your surroundings right now?
No.
Ms. Novotny, you had a chance to speak with Mr. Marshall prior to coming into court. And again, I'm not asking you to divulge the content of the communications, but do you have any concerns with when you were talking with him of his current mental state in terms of his ability to appreciate what's going on?
No, Your Honor, he was asking me questions and ultimately reassuring that he understood what was going on with going over the paperwork.
So you feel comfortable and confident going forward at this time?
Yes, Your Honor.
All right. Well, let's start over then again. Mr. Marshall, how old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yeah.
What was the name of that medication that you said? Keppra?
Keppra.
With a K?
Z.
How do you spell it?
Z-A-P-P-A or something like that.
Let's pronounce it again?
Z-A-P-P.
Yeah, but how do you say it?
How do you pronounce it?
It's Keppra. But the real name on it, it starts with an L. I can't pronounce that name.
But it's for seizures. So it's seizure medication.
Yes.
All right. Now, you should have received a copy of the indictment that was filed in this case. Looks like you got it at the end of July, middle end of July. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes.
Did you have the chance to look that over at some point?
Yes.
Now, in that indictment, you're charged with 4 counts. You're pleading guilty to... How many counts are there?
It's 5. I think the top of the indictment does say 4, but it is 5.
Second one today, I was like that. You're charged with 5 counts. You're pleading guilty to 2 of them. Count 1, it's alleged, and what you're admitting to is on or about June 26, 2025 in Willoughby Lake County, Ohio, that you didn't knowingly cause or create a substantial risk of physical harm to an adult female victim who was a family or household member and or a person with whom you were at the time or currently are in a dating relationship by means of strangulation or suffocation. It's further alleged you have previously been convicted or pled guilty to an offense of violence, that being attempted domestic violence in Cuyahoga County back on June 22nd, 2023, and or attempted aggravated assault in Cuyahoga County back on November 3rd, 2021. That conduct constitutes the offense of strangulation. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes.
Any questions about it?
No.
Now, in count 5, what is alleged is on or about June 26, 2025 in Willoughby Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to an adult female victim who was a family or household member, and that you have previously been convicted or pled guilty to domestic violence or an offense similar thereto, that again being in Cuyahoga County, attempted aggravated assault November 3rd, 2021, and attempted domestic violence in Cuyahoga County on June 22nd, 2023. That conduct constitutes the offense of domestic violence. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes.
Any questions about that?
No.
Now, there are 3 other counts in this indictment. Those are all being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about those 3 charges?
No.
Well, before I can accept your plea, I need to make sure you understand the right you're giving up by pleading guilty, and you first will have a right to a trial. Now, a trial could be to me as a judge, or I listen to the evidence and I make that decision whether you're guilty or not guilty, but you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of the charge. You understand that?
Yes.
You understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we had a trial, prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty at a trial. You understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden of proof there is in our justice system. And what it actually means is the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty of the charges. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes.
Now, in order to do that, or at least in order to try to do that, prosecutor would call witnesses to come into court to testify for the state and answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right to ask those same person's questions on your behalf. That's called cross-examination. She could ask them anything she wanted to within certain rules. You understand that?
Yes.
You understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want. Do you understand that?
Yes.
And you further can request the court issue an order. That order is what we call a subpoena. What a subpoena would actually do is it would force or make someone come into court to testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
You all right? Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that is your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is now allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that? You also understand if you went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Sorry?
I said yes.
Do you still want to plead guilty?
Yes.
Understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor regarding these two charges. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you are pleading guilty in count 1 to a felony of the 3rd degree. This offense is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So if a prison term is imposed, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve. You understand that?
Yes.
Now, count 5 is a felony of 5th degree. That's a domestic violence charge. That carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Now, since there's 2 charges here, if I impose a prison sentence, I'd impose it on each count. And as the judge, I have the discretion then to run those sentences either concurrent or consecutive to each other. Concurrent means that you serve them together at the same time. Consecutive means one after the other. You understand the difference there?
Yes.
So in this case, if I impose the maximum prison sentence and I ran the terms consecutive to each other, you're looking at a maximum possible prison term of 54 months or 4.5 years in prison. You understand that?
Yes.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Do you have any other charges pending against you anywhere?
No.
If a prison sentence were imposed in this case, upon your release from prison, you would be placed on post-release control. And it'd be mandatory in this case for at least 1 year, and it could be up to 3 years. You understand that?
Yes.
Post-release control is sometimes referred to as parole, which is a period of supervision you would be on, again, after you serve the prison sentence. And if you are put on post-release control, and you ever violate any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, whatever the prison term was imposed by the court. Do you understand that?
Yeah.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case on the strangulation charge in count 1. You could be fined up to $10,000. On the domestic violence charge, you could be fined up to $5,000. So altogether, there's a maximum possible fine of $15,000. Do you understand that?
Yes.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory with these charges. You are eligible for probation or what's called community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that, if that's what you're asking for. I'm going to look at all the information presented. Then I make the decision I thought was the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation or community control sanctions, it could be for up to 5 years. And as a judge, I had the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes.
Further, if you are put on probation of this court at any point and you ever violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years, if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation at that point and send you to prison then. And if I did it at that point, again, it could be up to 54 months in prison altogether. Do you understand that?
Yes.
Lastly, when we do come back here for sentencing, you're going to have the right at that time say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. And I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right. Well, do you have any questions at all about the potential penalties you face by pleading guilty?
No.
You understand all the possible sentences or what can happen at sentencing?
Yes.
Do you still want to plead guilty? Have you had enough time in this case to talk about the matter with your lawyer, have her review the reports with you, discuss the issues, and answer your questions?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has she or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today? Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering a guilty plea freely and voluntarily? You're not?
I know what I did was wrong.
All right, listen to my question though. I asked if you were forced or threatened to plead guilty, and you said you weren't. So my next question is, are you entering this plea voluntarily of your own free will? Do you know what that means?
You're doing it on your own. Like no one's telling you you need to do this.
I'm doing it on my own.
So yes.
So you're not being forced to do this or threatened to do this. This is what you want to do. All right, do you have any questions for me then at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
No.
Do you need any more time to talk to your lawyer before we go forward with your plea?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to her and what she says, because I got some questions for you about that, all right? Ms. Bell.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on June 26, 2025 in Willoughby, Lake County, Ohio, Eric Marshall did knowingly create a substantial risk of physical harm to an adult female victim, her initials being AC, by means of strangulation. AC was a household member of the defendants, and they were previously in a dating relationship. The defendant was previously convicted of felony offenses of violence, and those offenses were also domestic violence offenses or something that is substantially similar. The first being attempted domestic violence in the Cuyahoga County case number CR 23679-738A, and that was dated June 22nd, 2023. And the second being attempted aggravated assault in the Cuyahoga County case number CR 216555933A, and that was dated November 3rd, 2021.
Thank you. Mr. Marshall, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish at a trial if we did have a trial?
Yes.
What, if anything, did you have to say about those facts as she presented them? Are they true? Did you do as she said?
Yeah.
Very well, then, regarding count 1, charging with strangulation, a felony of the 3rd degree, what is your plea to that?
Guilty.
Regarding count 5, charging with domestic violence, a felony of the 4th degree, what is your plea to that?
Guilty.
I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Ms. Novotny, is that accurate? Did you read this over with Mr. Marshall, review it with him, answer his questions?
Yes, Your Honor, we reviewed it before coming in today.
Did he indicate an understanding of it?
Yes, he did, Your Honor. And we signed it in front of the prosecutor before coming in as well.
Thank you. Mr. Marshall, is that correct? You understand the document?
Yes.
Any questions for me about what it says?
No.
And your lawyer said that she saw you sign it. Did you in fact sign it?
Yes.
Ms. Bell, you witnessed that too?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, strangulation, a felony of the 3rd degree, in violation of Revised Code Section 2903.18b3, as well as count 5, domestic violence, a felony of the 4th degree, in violation of 2919.25 of the Revised Code. Counts 2, 3, and 4 will be dismissed at sentencing. Sentencing will be deferred, however. I'm going to order a pre-sentence report investigation, victim impact statement. Are you requesting any other evaluations, Ms. Novotny?
I believe a psych evaluation.
We'll do a psychological evaluation as well. Continue defendant's bond at $250,000 cash surety with GPS monitoring should be posted. And there's also a no contact order I'm putting in place. I don't think it was put in place with the arraignment for some reason. All right, Ms. Bell, anything else for the record?
Nothing further, Your Honor. Thank you.
The hearing nearly collapsed when the defendant claimed a head injury and confusion, forcing the judge to stop everything and test his clarity. After a long breakdown of charges, rights, and past convictions, the plea was finally accepted. A routine hearing turned into a complete courtroom disruption in seconds.